This is Budgeting 101 with Joni Kearn.
Good morning, everybody. My name is Joni Kearn. I specialize in financial services and the whole kind of financial realm. Today we're going to be talking about financial powers of attorney, and what it does is follows up on our last two conversations about wills and about healthcare power of attorneys. So those are all three very separate documents, and documents that you really need as an adult, anyone with a family. I mean, if you're all alone and all by yourself and you don't have any family, it probably doesn't matter. But if you do, then you need to prepare yourself and your family. And it is all about making sure that your wishes are fulfilled. It really is. That is number one. The other thing that it may do for you is to stop any disagreements or infighting that happens between your family. I know we all want to think that everything is going to be smooth as silk and everyone's going to work together. We know the reality is far different from that way too often. And I think it's the emotions that are involved. You know, we expect our parents to be alive and well and healthy forever. I mean, we really have that expectation. Or our friends, we don't expect to lose them. So I think when the emotions hit of people that we love not being able to take care of themselves, then it becomes an entirely different issue. Can you pass this over, please, so that I can be lazy? Thank you very much. So with the financial power of attorney, what it does essentially is it gives permission to someone to act on your behalf should something, thank you, if for some reason you can't act on your own behalf. And it goes from permanently, say we get Alzheimer's, which is very, very common as we age, to the point where we are just not cognizant anymore and we need help doing those basic financial things like paying our bills every single month, to having a stroke and being hospitalized or being in rehab for a while and you still aren't able to take care of those basic financial necessities. You want someone that you trust, that being the operative word, trust. You want someone to step in and be able to take care of those things while you can't, whether it's just temporary or permanent. Okay, so what I did was I literally just printed off the state of Wisconsin's financial power of attorney form. It's 15 pages, but it really is all inclusive. It is very easy to read, very easy to understand. I like that about this document because we get so accustomed to the legalese of lawyers' documents and not being able to understand them that it's nice to be able to read something that makes sense to you. So we're just going to kind of go through this, and then if you have any questions as we go along, of course this is interactive. So just interrupt me, okay? So as you go down, the first page just explains what a financial power of attorney does. It allows you to plan for your future needs. We all know, I mean, the chances of us being killed in an accident chances of us being in a car accident are like 6%. So the chances of us being killed in an accident are far less than that. The chances of us falling over from a heart attack, even though that's the way most of us want to go because it's nice and quick, are very, very slim. So what we want to do is we want to prepare for the future of whatever could happen. Because financial power of attorneys will step in and act on your behalf even if you fall over dead from a heart attack, but they will also help you through your final times to make sure that everything is taken care of as it should be, if you can live at home. and you have the bills to pay. You want to make sure those are taken care of if you just are in a position where that's a difficult thing for you to accomplish. And we don't want to look at ourselves. I mean, how many of us are really looking forward to the day when we can't take care of ourselves anymore?
No, we want a heart attack.
We do. My husband talks about that all the time. I want to just fall over dead from a heart attack. And that.
How about in your sleep?
Yeah, that too. I want to die with my shoes off. I want to just pass away. His Uncle Lee actually was sleeping, sat up in bed, put his legs over the side of the bed, and fell over deader than a doornail. Massive heart attack. No warning, no nothing. That's pretty rare. So we want to make sure that no matter what our demise is, that everything that we have is taken care of. And for those of us that don't have $1 million in the bank, it doesn't matter. My mom had a financial power of attorney. That was my sister. And it was, she didn't have anything. She didn't have life insurance anymore. She didn't have a lot of money in the bank. She was living on her Social Security. But what it did was it helped for what she thought was the eventuality of her being too sick to be able to live at home anymore and to take care of herself. And it allowed Lori to step in and do those kinds of things for her. So a couple of things that I found interesting is about halfway down this page. It says if you name your spouse or domestic partner as your agent and the marriage or the domestic partnership is terminated, the document becomes invalid. So if you get divorced and you're still best friends, document is invalid. So you would have to redo the document. So I think that's something that's pretty interesting to note, especially for younger people, because we should be talking to our adult children about things like financial powers of attorney so that they are prepared for their future as well. A lot of our children are married and 50% of us end up divorced. I mean, those are just the numbers. So it's something that's very interesting to note. If you used a former state power of attorney for finances form, that too is invalid. So if you used a form that is now out of date, and changed, you need to make sure that you do another one because it's invalid. Now, is the court going to say we're not going to count this and anybody can step in? Probably not, but they can, and that is something. Or if you have a child that is not your power of attorney and they want to be, and they find this information out, they can supersede your existing power of attorney. Oh, that form is still valid. I'm sorry. So much for my reading this morning.
Unlike the other previous two, it doesn't create a new one, does not invalidate the old one. You have to do something to invalidate the old one.
You do, and this goes through that. So you guys are right. I was not quite reading that correctly. I read it correctly when I read through this, and then, you forget because I'm not wrong. Isn't that right?
Right.
That's right. So executing a new power of attorney for finances does not automatically revoke a prior document. It's not exactly easy to revoke the prior document either. So it does need to be written. It does need to be in writing. And if you just do, and it is in here, if you just fill out a new power of attorney, it does not invalidate the old one. You have to actually invalidate your old power of attorney. So you want to keep that in mind.
In there already, and that first person dies, it just will go to the second person.
Absolutely.
If they don't want to, if they can't.
Absolutely. So say you named your first person and that person got hooked on heroin, probably not a good idea to have them be your financial power of attorney. So you want to name someone else, you can't just fill out a new document. You actually have to revoke the original one. Okay? And keep in mind that this is financial power of attorney. So this does not replace the healthcare power of attorney. So a financial power of attorney cannot make long-term medical decisions on your behalf. And that's important to note. Again, when we talk about wills, and we talk about healthcare power of attorneys, and we talk about financial power of attorneys, they really are three totally separate documents. The same person, and it was for my mom. My sister was her healthcare power of attorney, she was her executor for the will, and she was her financial power of attorney. It just made sense. So that's fine, and you can name all three, but you still have to have the separate documents in order to do that. Okay? So the next page is just the recording information. You can actually have this. This document legally recorded so that it is a matter of record, which means that if something ever goes to court, then the court has a copy of it. It talks about the third paragraph, and we talk about this a lot, and I think that there is no way to overstress the fact that if you put someone in charge of your finances, make sure you trust them. Make sure that they will act on your behalf. And there are legal avenues. If you have a power of attorney that is acting on their own behalf, there are legal avenues for other people to revoke that financial power of attorney. They can go through the court system and have that done. It becomes difficult. So how do you choose someone you trust? I mean, that's a personal judgment. We talk about, and I have talked many times about, I would probably not use a family member. That's my own personal belief. You have a daughter and you have a son. My mom had her daughter as a financial power of attorney. My sister was trustworthy to take care of those kinds of things. That I didn't have any question about that at all. But you do need to make sure that whoever you ask to be your financial power of attorney is someone that you absolutely trust to act on your behalf with your finances and with anything else that you own. Okay? It also provides this document, and Betty mentioned it and you mentioned it about having a second in line, which I think is important, because if something happens to your primary, you want to have somebody else named, and two people. You could literally name three, but two people is usually sufficient to take care of that. This form provides for the designation of one agent, though there is a spot in the form where there are some forms that are voluntary for you to fill out, so it does have a spot for a second person if you would like to name a second person. And again, I think that is something that should be stressed. I really think there should be a second in line, just because life tends to throw us surprises. And even though we talk about reviewing all of these documents annually to make sure that they are exactly what we want them to be and that nothing has changed, do we really? Probably not. We change it when we have to. We change it when we go, oh yeah, or something serious happens. You really do need to choose a time of the year, whether it's the beginning of January, the beginning of August, it doesn't matter. You need to choose a time of the year and make note of that and review your documents and make sure that everything is still correct and that everything is still exactly the way you want it. And that's an every year kind of thing. If your agent is unable or unwilling to act for you, your power of attorney will end unless you have named a successor. So therein lies the importance of having two people. As we age, the older I get, the less likely I am to name a friend as my financial power of attorney, because the older we get, the higher the chances of us dying. So, and I talk about that a lot, and it's something that we don't like to think about. We don't like to think about the fact that we're going to die, but we really are. I mean, I like to say I could guarantee you that 2 out of every 2 people are going to die. Just the way it is. So the older I get, the less likely I am to choose someone of my own age group, because I really want someone that can be in touch with my finances as I go throughout my life, and that I have more faith that they're going to outlive me. Does that make sense? They don't always, but they usually do. The power of attorney does become effective immediately. So as soon as you sign it, and you want to make sure, and this document says you want to make sure that you understand what you have done before you sign this, because it does go into effect immediately. The next page is the designation of the agent. So you name the agent, you put in the agent's address and the agent's phone number. Again, important to review this document annually, because our phone numbers tend to change. My phone number hasn't changed in 13 years. I mean, it just hasn't. Lots of times phone numbers change because lots of us now have cells instead of landlines, or we move. So we want to make sure that this information is correct, because this person needs to be able to be found. Right? And you need to be able to talk to them. It also has right below that the designation of successor agents, which is optional. The last section of this, which I think it's very important, and I thought it was interesting that it would be included. This is one of those things that if we decide to do these ourselves without the forms, or without legal advice, this is something we would miss. Because when I think of somebody being my financial power of attorney, I think about paying my bills. Do I go beyond that? Not really. Because I have a will that's going to take care of everything else. If it's stocks or bonds or annuities or retirements or whatever it is, you have a will that'll take care of that. So I think of just paying the bills. And we need to understand that, first of all, a financial power of attorney will give power over all of these things. And secondly, we want to make sure that we designate which parts of our financial life, because it's all of our financial life is multi-parts. We want to make sure that that person can take care of all of these different things. So it talks about real property, which is houses, those, that kind of real property. It talks about tangible personal property. It talks about digital property, which is your computer and all of the information in it, which I thought was interesting. Stocks and bonds, commodities and options, banks, operation, a financial power of attorney. If you have your own business, the financial power of attorney has the legal right and responsibility to step in if you choose this and to run the business. And for anyone who is self-employed and has a business, you should have a successor plan in line so that if something happens to you, the successor can just step in and it's as smooth a transition as it can possibly be. If you have a financial power of attorney, if you own your own business and you have someone chosen to succeed you, but you have a financial power of attorney that suddenly decides to step in and run the business, and you've given them the power to do that, they have the legal right to do that. And that's something that can cause a lot of angst amongst people. So something to keep in mind. Insurance, annuities, estates, trusts, other beneficial interests, claims and litigation. A financial power of attorney can act on your behalf if you have to go to court, or if somebody sues you, they can go into court, or you sue someone and then you become incapacitated, they can take over that role and they can continue to work on your behalf. Personal and family maintenance, benefits from governmental programs or civil or military service. When I was helping people with taxes earlier this spring, we actually had 2 people who were doing taxes for loved ones who had passed away. One was a daughter and one was a wife. So they have that ability to do that. They have to make sure that they bring along the paperwork that says that they are the financial power of attorney and they are the agent and they can act as such. If it's a wife, you just kind of assume that, or if it's a husband, I mean, that's just kind of assumed. But the daughter actually had the paperwork along with her, which we needed to see. And my sister took care of my mom's taxes for her after her passing. Retirement plans, taxes is an important one to keep in mind because you still have to file tax. If you have to file taxes, or if you choose to file taxes because you get a homestead return, then your taxes, you'll want to take care of those a year after your passing. First of all, it alerts the IRS that you've passed away. Social Security will do that as well. It's just kind of nice to have, because do we have faith that Social Security actually talks with the IRS? I don't know. Yeah, kind of, you don't know. So you want to make sure that everybody is aware of that. An agent there's limitation. An agent who is not my spouse or domestic partner may not use my property to benefit themselves or a person to whom they owe an obligation of support unless I've included that authority in the special instructions. So the financial power of attorney is empowered to act on your behalf and to do as you wish them to do. They can't just pay off their own bills or use your money or cash out your stocks or annuities and use it for their own good. The special instructions, I think, are I think that that's something that you should take a look at. Is there any something special that you want the financial power of attorney to do? Say you checked a box on the previous page that says you want them to take care of all of these things, but you really want to spell it out. So they're going to take care of paying your bills and paying your mortgage, and they have the right to take care of your property once you've passed away. But do you want them to be able to do something above and beyond, or something that has some detail to it? I want my house to stay in the family. I know somebody that wants the house to stay in the family. She has 8 children, and so the house will get divided up 8 ways. But she wants it to stay in the family, and she has set aside a trust that will pay all of the maintenance, taxes, insurance on that property for a long time to come. That would be something that I would spell out specifically in the special instructions. It's in her will and all of her children know it, but if it isn't in writing, it doesn't exist, is one of those things that the court will say. You know, they told me. Yeah, where is it in writing? Because if it isn't in writing, it doesn't exist. And we've all heard, who was that gal down in Florida that was on life support? She was very, very sick, and she was on life support, and she was in a coma and had been for years. And the husband kept going to the court. Her husband kept going to the court and saying, we talked about this. This isn't the way she wanted to go. Her parents stepped in, and it was years and years of a battle because it wasn't in writing. So the court didn't have any way of deciding between, and it actually went all the way up to the president. Do you remember that? I mean, it was just silly that it went as far as it did. The power of attorney, again, is effective immediately unless you have stated otherwise. So if you want the power of, say you have a financial power of attorney, but you don't want them to have control of your assets until year 2019 when their first mortgage is paid off, then you can state that in the special instructions. Of course, if something happens to you between now and 2019, who's going to take care of your stuff? So you do want to make sure that your special instructions are clear, because we all have those little caveats to what we want that says, you know, I want them to do this except for, or in addition to, or I want to make sure that this is done exactly the way I want it to be. Nomination of guardian. If it becomes necessary for a court to appoint a guardian of my estate or guardian of my person, I nominate the following persons for appointment. And I think this is something that we should consider. It needs to be a different name than your financial power of attorney. But if it goes to court, who is going to be your guardian? Because if it goes to court and you haven't named a guardian, they choose one. And the courts have guardian ad litems is what they call them. So what they do is they just put somebody in the place. Do they know you personally? No. Do they know exactly what you want? No. Are they going to be able to act? They will try to act on your behalf, but will they really be able to? No. So if you have a guardian put in place, or you have nominated somebody to be a guardian, if for some reason this all ends up in court, then you're protected. That isn't as necessary as naming a successor. If I had to choose which of those three were number one, first of all, naming somebody to be my power of attorney is first. Naming a successor is second, because I want to make sure there's a second person in line. A guardian is something that if my financial powers of attorney are doing their job, then a guardian wouldn't be necessary. So that would be third on the list. Anyone that you name, and this is the next page, anyone that you name can rely upon the validity of this power of attorney or a copy of it, unless that person knows that the power of attorney has been terminated or is invalid. So if you invalidate your first power of attorney and you write a second one nominating someone else to be your financial power of attorney, then this is valid unless that person knows that the power of attorney is invalid. So as difficult as it may be, if you decide to change powers of attorney, let's say my mom decided on a whim to change my sister from power of attorney to me. My sister would have been very, very angry. Is that a conversation my mom would have wanted to have? No. Oh, no, 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 no. So you need to make sure that you have that difficult conversation and you say, I have switched powers of attorney. Maybe because your power of attorney moved out of town, but someone else moved into town, and you just want to make sure that whoever is there, like you were talking about, is close enough to be able to come over to the house and balance your checkbook. Or maybe it's because something happened with your power of attorney. They were in, I have a brother-in-law that had a brain aneurysm, and it has actually caused a loss of some of his mental faculties. He's perfectly able to take care of himself, but he has had to give up motorcycle riding, which was his passion, because he doesn't have the balance anymore, and he is no longer able to make final decisions on some of the finances because he gets a little confused. In that case, you would have to rename your power of attorney. And I believe my mother-in-law had him named as her power of attorney. So I hope that she has changed that. So that is one of those instances where you need to revoke a document, you need to write a new document, and you need to make sure that it's current. Because Rick was in his 40s when this happened. We don't expect that kind of stuff, you know, and my mother-in-law is 91 or just turned 92 or something like that. So you don't expect to have those problems and to have to face those decisions. But those are decisions that we do have to face from time to time. So you want to make sure that if you revoke one power of attorney, that you put something else in place. The next page is the important information for the agent. Should your financial power of attorney have a copy of this document? Yeah. Copy of your will? No, because your will is what talks about where you want your wedding jewelry to go, or where you want grandma's emerald necklace to go, or those kinds of very personal things. So whoever you choose as executor needs to know that they are executor of your will. They don't need a copy of the document. They don't need that. But your financial power of attorney should have a copy of this document or be able to get to it. They need to review it. They need to read it. They need to be able to get to it easily. And that goes back to how we've talked about having a file for your important papers and having someone else know where it is. In my house, I have everything organized, kind of. And I have my file of important papers. Could my husband find it if something happened to me? No. Because he has no, I'm gonna die before you are. I don't need to know all that kind of stuff. And my brother and my sister-in-law went through the same argument. It was kind of funny because when Scott had cancer, he kept telling Carolyn, his wife, you need to know what all the passwords are to all of our online accounts. No, I don't, because you're going to be just fine. Because, you're getting this, you're getting all of these treatments and you're going to be healed, and I'm not going to take on all of that responsibility. She was already taking care of all of her mom's finances, so it would have been additional. Did she need to know where all of that stuff was? Yes. Did she? No. My brother had a file that had everything listed, and he updated it. So when he did pass away, my sister-in-law, when she got the file, was able to look at all of those passwords, and she had them because my brother was one of those super organized people that had a different password for every single account, which you should have. I have the same. I have 2 or 3 passwords, and I use because remembering that kind of stuff. And there are people who have a file on their computer that has all of the passwords for all of their accounts, and it's password protected. And you can do that unless your computer dies, I guess. But that's, I digress.
Oh, it's handleable. Not a good place to have it.
No. See, I think I'm a paper person. I mean, aren't most of you? We come from the age of paper, so we tend to be paper people, where we like to see it in writing, and we like to be able to take notes, and we like to be able to fill in forms, and we can do a lot of that on the computer now, but it's more comfortable. It also, by the way, is easier on our eyes.
My passwords are on a couple pieces of paper laying on the kitchen table.
You should hang them on your. You should hang them on your fridge with a magnet.
Yeah, there you go. I have some. I could put it on the fridge among all the grandkids' drawings, and nobody would find it.
The most obvious is the least noticed. It's kind of funny. If you put something in front of their face, they're never going to see it. Me and telephone poles have that relationship. The more obvious it is, the more likely it is that I'm going to walk right into the thing because I won't see it. But your kitchen table is probably less than ideal place to keep all of your passwords. Just saying. At least if they're on the fridge with a magnet, they're attached to something. Hide it in a little, I have this, it's really kind of funny because I have this miniature metal garbage can. Those garbage cans that have the round top, that have that hole, the cover in the middle, and you put I have a miniature one. The thing stands about, and it's this absolutely beautiful sky blue. And it's right on my desk. And it has been sitting in the same spot on my desk for a couple of decades. My husband has no idea it exists. It's right there. It always has been there. It's just tucked off into a corner. It's perfectly visible. I have been known, I use that as my stash. So when I have an extra buck in my wallet, I just tuck it in there. And then every 6 or 8 months or whatever, I have to actually open the thing up and count how much money is in there. Because I've been known to forget, but that's my own, that's my stash. That's the emergency. I need gas money and something came up last week that I had to pay for kind of stash. But my husband has no idea it exists, or he would rate it, is what he would do, and then I'd have to put, some kind of a lock on it or password or something. Anyway, important information for your agent about their duties, and it goes through the entire list. You need to do what you know the principal, which would be those of us that have this document, reasonably expects you to do with their property. So they have to act in good faith, in your best interest. Do nothing beyond the authority granted in this power of attorney. Disclose your identity as an agent. They should have a piece of paper so that if they have to go in and talk to the bank, or if they have to, and the bank would probably have that piece of paper, but if they have to go in and talk to an insurance agent or go do taxes, you want to make sure that they have a piece of paper that says, I am the agent for, or they can be turned away at the door. I mean, that is privacy policies, that unless you say I'm the agent and can prove it, they're not going to give you any information on the account. And that goes for if they're wives and husbands. It used to be, when I was a child, my mom signed all her checks, Mrs. Menser Johnson. It was her name. And everybody accepted that. And she could go anywhere and say, Mens wants to know whatever, and they would give her the information. My husband has a charge card just in his name, and I have access to it. I'm the one that pays the bill. So I call a credit card company and they say, yeah, we won't talk to you. Unless your husband gets on the line and specifically says, you can talk to my wife, they won't talk to you. So you do need to make sure that they have something that says that they are your agent, that they can show people. Which means that having it done legally and having it signed and notarized can be pretty important, because I can get on a computer and print that out and sign it, right? And nobody would know any difference. So you want to make sure that you do that in your best interest. So this talks about, next it talks about the special instructions. You have to, and all of this really is about acting in my behalf. If you are my financial power of attorney, you are legally obligated to act in my behalf no matter what it is that you take care of for me. So you have to be loyal, you have to avoid conflicts, they have to act with care, competence, and diligence. They need to keep records of all of the receipts and the disbursements. I talked to someone just recently who had a financial power of attorney that didn't keep any records of anything. So they didn't have any idea what was going on, and they weren't particularly responsible, and none of the rest of the family had anything going on either. So, I mean, if another person, another one of your loved ones, another child, comes to the financial power of attorney and says, how are things doing financially? It's my job as the power of attorney to answer that question and, avoid the conflict. I don't get to just say, well, that's my job and you don't get to have any say and I'm not going to talk to you about it, unless it crosses a line with, I want to make sure I want to pay the bills, or I want to balance the checkbook to make sure you're doing your job. I mean, that crosses the line into taking over the power of attorney duties, but they do have to talk to each other. So if you have siblings, say your son comes to your daughter and says, I'd like to see the books, I just want to see where she's sitting. Your daughter has a responsibility to talk with him about it. She can't just say no. Once we are dead, the financial power of attorney ends and the will takes over. Okay? So we want to make sure that we understand that if my sister was the financial power of attorney and I was the executor of my mother's will, the minute she died, I am now in charge. And my sister is not, because it ends at the death of the principal. So she would, my mom's financial power of attorney would end, and I would take over as soon as mom died. So we want to make sure that we understand that. Again, it's a difference in documents, and it underlays the importance of making sure that you have your entire package together for your future and for yourself and for your family and for anyone else or any other organization that you care about, that you have designated something for them to have. We need to make sure that we have these.
So the executor of the will would take care of paying for that funeral luncheon and anything left, not the power of attorney?
This is only for when you're alive, but incapacitated.
Yep, power of attorney. The power of attorney's authority ends upon the death of the principal. So the executor has the power to pay all of your last bills, to divide up your property, to sell your house, to do anything that you want done after your death. If you're going to give your financial power of attorney, let's say you end up in a nursing home and you're incapacitated and, it's just one or the other of you, and you want your home sold to pay for your nursing home costs, then that would be power of attorney because you're still alive. But if you want your home taken care of after you're dead, now that falls to the executor of the will. And if you have if you have several children and you really want to have them all involved as you come to the end of your life, then have one be the financial power of attorney, have one be the executor of the will, have one be healthcare power of attorney, fill out your little special instructions that say, you three must work as a team. I have named one of you to be ultimately responsible for this particular job, but I want the three of you to work as a team for my end of life. Would that happen?
No, not in my house. I have two sons who won't talk to each other.
And unfortunately, that's more common than it is to have a family that would all band together. I just had a friend who was in a very, very serious accident. And his mother, who loved her daughter-in-law, once the accident happened and now her daughter-in-law has to take care of all of this stuff, decided her daughter-in-law was the worst person in the world. And was very angry. And that is the emotions of watching my son in a hospital bed and we don't know if he's going to live or die. That's the emotions of that. But it went from you're the greatest girl in the world to you are an awful wife and you have no right to take care of my husband. Like that. And that's how it works. And if you have kids that don't talk to each other, it makes it even more difficult. And my family is like that, by the way. And she had, Mom had 6 kids. 3 of my brothers predeceased her. So it was just my sister and I and my one brother remaining. And we were all there when she passed away. That is what she wanted, and it's amazing how that kind of stuff happens, but we all were there when she passed away. And her primary caregiver, her hospice nurse, looked at all 3 of us and said, your mother wants nothing more than for the three of you to get along. And we three were all standing there going, yeah, no. So, I mean, can you imagine if it would have come to something where we all thought that we were the best person to act on her behalf and the other one wasn't? What kind of arguments would ensue and how distrustful we would be? As it was, I mean, it was fine that my sister took care of it. And I don't think she followed all of my mom's wishes. My guess is that she ignored, because my sister was really good at saying, well, I need to decide what is best for her. So that supersedes what she wanted. But in the end, I think it all turned out. Okay. And you chuckle, because you've never heard anybody say that before, have you? I mean, that kind of stuff happens. Again, that's where the special instructions comes in. Because if it is something serious, you want to make sure that that is taken care of and that it is all spelled out and that someone doesn't have so much power that they can start to say, this is what I'm going to do instead. Okay. So, the liability of the agent. And this goes into the Uniform Power of Attorney for Finances and Property Act in Chapter 244 of the Wisconsin statutes, which is very close to the same as this form. I did go through it just to see. You can be liable for any damages caused by your violation. So let's say your financial power of attorney steals the $5,000 in your annuity. And everybody that is part of your will, part of your family, is aware of this. They are legally liable because they violated, unless you have special instructions that you want that, they are legally liable to follow the power of attorney. So stealing your money, which happens, by the way, is something that isn't allowed. So they should read and accept this. There are several places in here that they have to read. By the way, and I think we're going to get there, but just in case we don't, for someone to act as your financial power of attorney, they have every right to get paid for that. So they can get paid however you want them to get paid, but they can get paid a reasonable amount of money. Now, your $5,000 annuity for paying your rent every month is probably not reasonable. So that can be disputed. But you can put in there that, I want my power of attorney to get $500 on the first of every month to take care of all of this stuff, because it's hours of work. I mean, you can do that. You can name the amount that they should get paid, but you need to know that they have every legal right to get paid for their services. Okay? When my friend's mom was on hospice toward the end, she had hospice coming in to take care of her. My friend decided to be her hospice full-time. And because she was quitting a job in order to be able to do that, her mom, and those two kids, by the way, are one of those families where they actually got along great through all of this. But her mom paid Greta whatever hospice would have made, whatever she would have paid hospice to come into the home. So she made sure that Greta was financially reimbursed, and her brother Mark didn't have any problem with that, which is fabulous, actually, because toward the end, Greta was writing out her own paychecks. But it was something that her mom had talked about, and you want to make sure that you do all of this while you are still perfectly able to do it. Because the last thing you want is someone to go to court and say they were ill, they were not able to make those kinds of decisions, and they were coerced into this, because that just causes a whole myriad of problems that you don't want to face. So the next one is just another signature and a certification as to the validity of the power of attorney for finances and property and the agent's authority. And the first one, just to reiterate this, number one, the principal is alive and has not revoked the power of attorney or my authority to act under the power of attorney. So again, it is good up until your death. Phew, we made it through all of that. Everybody understood every single word you read, right? I know. Isn't this a huge document? We do have 10 or 15 minutes for questions. The rest of this is the appendix, and it is all of the definitions. So it goes through defining what real property is, what digital property is. I had to look at that one and make sure that I was right. Tangible personal property, stocks and bonds. It goes through all of that and just kind of explains it to you. It talks about if you have a business, which we talked about, estates, trusts, personal and family maintenance. I mean, it goes through all of the things that we talked about so that you can take a look at them. Because if you look at stocks and bonds and you say, well, if this is my IRA, which is in the bond market, probably, is it a stock and bond or is it a retirement account? And those are the kinds of things that you can look at the definitions. And if you're confused, then you do IRA/bonds to make sure that they're understood, or you put it in the special instructions. George gets my IRA, whatever. I mean, you just want to put that, or he gets the payments for my IRA, or the payments for my IRA are what's paying the financial power of attorney to take care of all of my finances until my death, or however you want to do that. So it's a big document. So I really wanted to just spend the time to go through it with you so that you had a lot more questions than you did answers. Isn't that a great idea, Betty? Let me confuse you further. But it gives you a lot of information to sit down and read and take a look at. And if you already have a financial power of attorney, this is a great time to take a look at it, to review it, to make sure that it's exactly what you want, and to make sure that all of the things that this document allows them to do on your behalf are really things that you want them to do on your behalf.